Welcome back to the courtroom breakdown that will leave your jaw on the floor. Today, we're diving into one of the most intense pro-Southeast legal showdowns we've seen this year. On one side, Mr. Crucell, self-represented, emotionally charged, and unwavering in his constitutional beliefs. On the other, a seasoned judge, balancing order, law, and rising tension in the courtroom. Motions are flying, contempt charges are stacking, and a jury is waiting in the wings. What begins as a routine motion hearing quickly spirals into a heated exchange about due process, jurisdiction, and judicial bias. Stick around, because the emotional stakes are high, the courtroom is on edge, and this case takes turns no one saw coming. Think the judge went too far? Or was Mr. Crucell pushing the line? You decide. Let's get into it.
All right, so Mr. Crucell, you filed a number of motions. I'm going to let you pick which one you want to deal with first.
Well, this emergency motion stay needs to address the request for judicial bias and due process violation.
Okay, just hold off with the argument. Hold off with the argument. The question was, what do you want to start with? Okay, so you filed something Friday. I took a quick look at it today. Is that any different than the motion to stay that you filed previously?
This is just bringing the fact that all the motions I have filed.
Is that a yes or no, Mr. Crucell?
Well, it's covering all the judicial bias.
Okay, listen to my question. Is it any different than the last motion to stay proceedings you filed? Okay, just give me what you've added since the last one, because this one I haven't had a chance to read fully. The first one I read fully.
I just have the same straight face on you. Didn't give a shit about what I had to say.
Okay, hold on. Mr. Crucell, this is going to be a very long day for you if you don't listen to my questions and answer my questions. That was in the original motion to stay proceedings. I've asked you to give me whatever's new in this motion.
New stuff covers that she agreeing telling me to sue the Secretary of State rather than addressing the due process violations in my case.
Okay, stop right there. How does that lead to why this should be stopped today?
All of this is stemming from where all of this should have been stopped a while ago.
That's not the way it works. Mr. Crucell, hold on. Okay, that's the last time you're going to interrupt me today without a contempt of court charge. Is that clear? Is that...
Boom, the judge draws the first real line in the sand. One more word and it's contempt of court. This moment sets the tone. What we're witnessing here isn't just courtroom procedure, it's a psychological chess match. Mr. Crucell is clearly frustrated, but interrupting the judge in this setting is high stakes. Judges can and do use contempt powers to maintain courtroom order. Was this a fair warning or judicial overreach? Let us know what you think in the comments.
Is that clear?
No one has made her answer.
One more word, and it's contempt of court. It's $100 a contempt, and if I get totally fed up with it, then I'm putting you in jail. Okay? Just because she and I happen to agree on the law as it applies to your case doesn't mean we're in collusion. It's possible that you're wrong. At least accept the possibility that she and I have the same opinion about something. That doesn't mean we're colluding. You understand that concept? Do you understand that concept? I am impartial. I've been trying to save you. Just because I agree with the prosecutor doesn't mean I'm against you. It just means I agree with the prosecutor.
So it means you're agreeing to that. That means you guys are lying against us.
So that means in any case, when I buy the arguments from one side, that means I'm colluding against the other.
You're agreeing.
Yes or no, Mr. Crucell? No, you have to answer my question. Contempt number one, $100. Answer my question. Every time I rule in favor of one side, does that mean I'm colluding against the other? Yes or no? $200. Yes or no? Because I can do this all damn day. And when I get tired of this game, then I tell them to put you in custody because it's contempt of court.
The courtroom just hit DEFCON 1. With every unanswered question, Mr. Crucell racks up another $100 contempt charge. The judge is crystal clear. Disagreeing with a ruling isn't a license to accuse the court of conspiracy. This is critical. In court, objecting without a legal basis isn't just ineffective, it can land you in serious trouble. Are we watching a man exercising his rights, or someone unraveling under pressure?
It's contempt of court, criminal contempt in my view.
Yes.
It is. All right. So now, any argument you make from there, I'm going to deny because that's an unreasonable position you're taking. Judges, by definition, have to decide in favor of one party or the other. That's what we do.
Right. When you made that statement, you were making.
What statement is that?
It was
I thought we were talking about Judge Green's SOS statement.
when you made this statement that you were setting aside my regular Travis saying that you're saying that the prosecutor, the township, and his court all see things the same way, setting that all aside, not even allowing me to make my argument. So you were aligning yourself with the prosecution on the argument of my like and setting it aside. That's what you were doing.
Mr. Crisell, what I was doing was aligning myself with the law as I see it and interpret it. Stop. You can't just shake your head. You don't just disagree with me and move on. If you don't like a ruling from a judge, you have to appeal that ruling. You don't keep arguing with the ruling. That's not the way the process works. Listen, brother, listen. I have tried to save you from yourself. If you remember the first time you were in my courtroom, I tried to get you to see things the way the process was going to move forward. Because, dude, this process is going forward the way I want it to move forward. You might not like that, but I'm in charge of the courtroom. And at the end of the day, if you don't like anything I do, you can appeal me. That's why they have circuit courts. But I'm not going to let you make this a dog and pony show, especially when we've got jurors here.
Dog and pony show. This court fails to let me make any of my statements, any of my cases. You even were trying to threaten me with contempt. Anytime I tried to...
I am threatening you with contempt.
My objections on the make my things.
No, because third contempt. Do not interrupt me. When I said your objections don't mean shit to me is because you were using the word objection inappropriately. You objected every time I disagreed with you. If you have an objection, you have to have a legal basis for the objection. For example, she's trying to put a video into evidence. And you say, I object, Judge. She hasn't laid a proper foundation because all she said is, Judge, I've got a video. I'd like to play it for the jury. That's a proper legal objection. When I rule in her favor and you say I object and I say, what's your objection? And you just disagree with me, that's not a legal objection. That's why I said your objections mean shit to me because you're not using the word appropriately. Because you don't know what you're doing. That's what I tried to tell you originally the first time you were here. You've never been to law school. You've never tried a case. You don't know the rules of evidence and all the other things that have to be in play to have a trial go forward appropriately, properly, and to be perfectly honest, in your best interest.
And you're trying to spin the sheriff's office.
I'm not spinning.
My objections based on you not allowing me to do it. And that's what you told me.
Okay. All right. So let's do it this way. What motion would you like to address first? The motion to postpone? Denied. I'm not denying the jury trial.
I'm not denying the jury trial. And just like that, the judge tries to bring focus back to the case at hand. But let's zoom in. There's a real disconnect happening. Mr. Crisell is entangled in constitutional arguments while the judge is trying to adjudicate a local citation. This happens more than you think, when sovereign citizen-style arguments collide with statutory law. Legal drama? Definitely. Productive? That's up for debate.
She never wants to debate why is it on the prosecutor to prove those things. There's all sorts of irregularities.
All right, let me stop you for a minute. What do you mean you're not going to proceed? You're here.
Everything is taking place now shows the extent everything there is enough to show you're supposed you need to.
Once again, you're not answering the question I asked. You just said you will not participate, and I asked, what do you mean by that? I'm not asking you to explain your reasoning. I want to know, what does that mean? I'm not going to proceed with this. You're here. So when I impanel the jury, what? You're just going to sit there and not going to talk? What does it mean when you say you're not going to participate?
Go through until these things get addressed. All of my issues that have been ignored this entire time, especially excluding people.
Once again, if and I deny it, it's been addressed. You might not like the way it's been addressed, but then you have to appeal it.
That's the point of getting all my objections.
All right, what's your objection? What's your objection to me denying your motion to postpone this trial at the last minute?
Like put on record, and then whatever you would like to do from there, you can, because I don't until these things. Like I say,
Hold on. Is this statement preceding all these motions you filed?
All having
Okay, then let me make my ruling on all of them. I think there's a motion to dismiss for lack of jurisdiction, correct? Okay. Would you like to respond to that one? Because I think that's already been addressed.
We arrested Mr. Purcell while he was in Huron Township, but Bigger District Court has jurisdiction over offenses that occur within the township, both civil and criminal and
Did you appeal Judge Green's decision on that motion?
I'm investigating because I've been in contact with the appeals.
Okay, so there's no appeal filed yet, correct?
Getting all the involved.
I'll take that as a yes. There's no appeal filed. That motion is denied then. She made the ruling. You don't get to ask me to make the same ruling. Once again, don't interrupt me because I can go to 4 real quick. Judge Green, a judge in this court, ruled on that exact motion and denied.
Let's break this down. The judge makes it plain. Jurisdiction was already ruled on by another judge. Mr. Crucell hasn't appealed that decision, so the court is moving forward. This is a vital legal lesson. If you disagree with a judge's ruling, your next move isn't to re-argue it, it's to appeal. Otherwise, courts treat the issue as resolved. The tension? Still rising.
Motion and denied your motion. That motion has not yet been appealed, and it certainly doesn't get appealed to me. Is that clear?
Yes.
Thank you. Next motion. Motion to,
The judge can't just come in here and say that
yes, the judge can. But listen to me. Then appeal her to circuit court. A judge made a ruling. You don't get to keep arguing that same motion.
All she said was that Judge Martin was sending a sign and that I should go sue the Secretary of State. The things that she's claiming and saying were never said to me. And anybody have all the recordings and were submitted to the court. These things were never said to me. And then she comes in here and makes these accusations and saying that the judge said this, the judge said that.
Fine. Then I'll say the same. I'll say the same thing to you. Listen to me. Here, on your motion to dismiss for lack of jurisdiction, denied. By me, you can appeal me. Because the reason she stated, the Township of Huron issued you a citation. This court has jurisdiction over citations issued by the Township of Huron. So for that reason, I'm prepared to move forward and adjudicate that citation. Is that clear enough so you can appeal my decision?
Fine.
Okay. Next one up is motion to reconsider for bias and judicial misconduct. Denied. Would you like me to clarify that in any way?
Yes, absolutely.
Okay.
All the reasons I've stated, there's
Okay. Then guess what? The Court of Appeals can overturn me because I'm not biased to you. You might not like the way I talk to you. You might not like the things I say to you, but I'm not biased against you. Believe it or not, brother, I would like to save you from what's going to happen today.
You've turned a minor misdemeanor into a huge mess. That line sums up the court's view perfectly. The judge is trying to bring things back to a manageable scale, but Crucell's grievances have ballooned the case. This is the kind of escalation that fascinates and frustrates legal professionals. Pro se defendants have the right to represent themselves, but without legal training, these cases can spiral fast.
I really would. Because here's my dude, let me talk. You have turned what should be a fairly minor misdemeanor and civil infraction situation into a huge mess. I don't think it's going to end well for you. I tried to save you from that the first day you were here when I tried to convince you to have some conversation with a court-appointed attorney, and you didn't want to do all that. I know in my heart of hearts, I have no ill feeling towards you whatsoever. And I'm going to give you the best trial I can give you today if you decide to participate. But I am not going to let you drag things in front of this jury that I determine are not relevant because that's my job as the gatekeeper after the judge over the trial. I'm not going to let you get into a bunch of arguments that I think are just going to cloud issues if I don't think they're relevant. That's my job as the judge, not because I don't like Mr. Crucell. It's because my job as a judge is to run this trial efficiently and effectively. And I'm going to do that. And if I do that, I anticipate I'm going to step all over your toes and your beliefs. But that doesn't mean I don't like you or I have bias against you. So I am denying your motion to recuse myself. Anything else you want to put on the record so you can appeal that decision?
Go ahead.
Once again, stop. That's an improper use of an objection. What you want to say is, I disagree with that, which is fine. That's why you appeal it to the circuit court. But it's not an objection. What's your legal objection to my ruling? That's not a legal objection to a ruling. That's not a legal objection. So that's 2 motions down. The next one is motion for relief from judgment. I'm assuming that's Judge Martin's decision to set aside your defaults. All right. Do you really want me to grant that motion? Because if I grant your motion, that means the default that was set aside, defaults that were set aside are reinstated. Is that really what you want today?
Well, listen,
Mr. Purcell, yes or no? You filed a motion asking me to set aside a decision that was made. Do you really want me to set that decision aside? Because that means those civil infractions are then in default and they're done. Is that a yes or no? Yes or no? Do you want me to set aside those do you want me to set aside the default set-asides? Do you want me to reinstate those default judgments? Then I'll deny that motion.
Ah, the motion for relief from judgment. The judge offers a reality check here. Granting that motion would actually hurt Mr. Crucell by reinstating default judgments. This is why legal advice matters. Without it, defendants can file motions that contradict their own interests. It's a pivotal moment that shows how good intentions in court can go horribly wrong without strategic planning.
All right. You filed something called Notice of Constitutional Rights, which I didn't see anything where it required me to make any decisions or anything else. You're just letting me know that you're standing on the Constitution? So am I. All right. The emergency stay we dealt with. You also file an affidavit of non-consent. You didn't need to file paperwork for me to know you didn't consent with the proceedings, but I got the message there. Was that the only message I was supposed to get out of that document?
essentially, yeah.
Okay. Okay. I don't need a preachy moment. I just want to make sure I wasn't supposed to get anything else out of that affidavit other than you don't like the process that we're involved in. Next thing I had on my list was affidavit of non-consent. Oh, excuse me. Motion for judicial notice. What does that judicial notice of what?
Certain terms that this prosecutor keeps trying to use and apply in this case that are not the lawful terminology being used.
Okay. For example.
You use motor vehicle.
Okay. Motor vehicle's pretty much a term of art in our business.
Law limits how it's being used. Absolutely.
Well, then you can make those arguments. But you can't tell her she can't use that phrase. Yeah, but I'm not the trier of fact. So if you want to make an argument to the jury that her use of the term motor vehicle is improper, you can make that argument. Is that what you're concerned about? Is you're not going to be able to make the argument?
Yes.
Get what stuff on the record?
Filings.
Well, I can guarantee you're not getting all these filings on the record because the jury has no reason to know about all your motions.
All of this has to go. Everything is taking place.
No.
Exactly.
No, that's not the way it works, Mr. Cazell. No, Mr. Cazell. All right, listen, brother, listen. You don't get to tell me what my job is. I've been doing it for 25 years. Listen. Well, then that's why they have appellate courts for the 4th or 5th time. I decide what this jury gets to see today. I decide. That is, by definition, the role of the judge at a jury trial. I get to decide
what the jury gets to see. This is a crucial point of law. The judge acts as the gatekeeper. It's their role to ensure only relevant, lawful evidence reaches the jury. Mr. Crucell argues that this limits his case, but from the bench's perspective, it's about protecting the trial's integrity. What do you think, fair control or silencing tactics?
I get to decide what goes in front of that jury. If you don't like the decisions I make, you appeal those decisions. That's the way it works. What this jury has to decide today is whether or not you violated the township ordinance on that date. Hold on. None of these legal arguments about whether or not I should recuse myself or whether or not you notice me up for constitutional rights, none of that has to go to that jury. And none of it's going to.
That's why they should have tried and not emergency stop motion stop.
I already ruled on that.
Circling back acknowledge my emotions for my next travel.
Once again, I'm doing my function as a gatekeeper for a jury trial. I'm deciding what's relevant and what's not. And you can disagree with me that all day long. But we're going to do it, once again, we're going to do it my way. You can appeal me. I've been appealed before. I'll probably be appealed before I retire again. It's okay. That's the way the process is set up. I encourage you to appeal me. All right. I am open-minded enough to think that perhaps my mindset about your whole travel thing, maybe that's all wrong. So a circuit court judge can tell me I'm wrong. But so far, and I've ruled this way a number of times on the traveling issue, nobody's ever appealed me to lead to a circuit court judge to tell me I'm wrong. But I'm open to that idea.
I've said, well, you just keep, each judge has done the same thing. They just keep setting it aside and acting like it doesn't even exist, not allowing me to make my case, which is violating my rights to be able to produce my case in my head.
What's your case that traveling doesn't mean operating?
I'm sad in the fact that this court's violated my due process rights in every way, the judicial bias. And
All right, then appeal me. But today we're having a jury trial.
An unlawful jury trial, and I think that late statement in the record.
But
Things get even more emotional here. Mr. Crucell claims the trial is stacked against him and accuses the judge of aligning with the prosecution. The judge, clearly frustrated, pushes back. Here we see the deeper issue, trust. When a defendant feels unheard or targeted, every ruling becomes suspect. Can this courtroom recover its legitimacy in Mr. Crucell's eyes?
But hold on a minute. Once again, I want to know what that means. You're not participating.
Not participate in a jury in a trial where there is clear bias in this court against it.
Okay.
Violates my rights to a fair trial. 100%. And you want to keep overlooking. I know they make you seem like they're not a big deal. And
No, your rights are a really big deal.
obviously not, because if you can sit there and say that the things that are happening, the things you're saying, and just try to give this excuse to all, just because I agree on this, you are aligning yourself with the prosecutor on my right to trial, completely setting aside, not allowing me.
Mr. Crucell, no, I'm not. Listen to me. No, it's not. Listen to me. Listen to me. She could step out of the room, and I still think your travel argument is bullshit. Traveling, the right to travel was when you did it by Shank's mare. Then appeal me. That's my decision. Appeal me. When you're driving a motorized vehicle or traveling in a motorized vehicle, that brings all those ordinances.
Let's talk about the right to travel defense. It's a popular but largely unsuccessful argument in court. The judge firmly rejects it, citing decades of precedent. What stands out here is his offer, appeal me. This line is repeated like a mantra throughout the hearing. It shows how the judge tries to anchor the trial in legal process, not personal emotion.
Brings all those ordinances into play. That's my legal ruling. Appeal it. I encourage you to do that. But that whole traveling argument, which, dude, I've been through that argument a whole lot more than you have. Trust me, in the last 25 years, I've had that argument a lot. Traveling, as you try to apply it, meant you could not be stopped by the government from walking from one venue to another. But when we got motorized, then the rules kicked in.
Rulings from the American jurisprudence side that literally stated that yes, first of all, you're allowed, and including automobiles, as long as one does not interfere with another's rights. And this is something that is subject to be secured.
Then appeal me. Take that precedent and appeal me.
As well.
Okay, that's your right. I'm not trying to stop you from doing any of that stuff. I'm just trying to stop you from bogging down this jury with stuff that I've determined is not appropriate today.
Because just because you're determining it based off of what though? That's what I'm saying. All these things are relevant and they are accurate.
They're relevant to you. They're not relevant to me. I've made the decision. I have made the decision. I made that decision months ago and you didn't appeal that.
I mean, the process
Which is not an appeal.
Is a extreme, lawyer, but there's bullshit that you can't do that.
Absolutely, I do that.
100%.
No. Listen to me. If I don't hold you to the same standard I hold her to, then I'm treating you differently than her. How is that unbiased and impartial? You've decided to engage yourself in this venue, in this arena. That means you got to know the jury structure. Yes, you have.
I'm forced to be here.
But you didn't have to do it. You didn't have to do it as an untrained layperson. You had free access to qualified, competent legal counsel. They're still here. There's one right there behind you. He's still ready to help you. You chose to do this yourself. That means you've got to know the court rules. You've got to know the statutes and the ordinances. You've got to know the rules of evidence. And if I help you through those lapses in your knowledge base, that's not fair to the prosecutor. Then I'm taking sides. And now I'm not going to let her walk all over you and try to trick you because you don't know some of those rules and statutes. But I am absolutely going to require you to know what you're doing because you've chosen to do it. That doesn't show bias. That shows impartiality.
There's no impartial anything. I have the.
Once again, Mr. Crucell, that's your opinion. No, it's your interpretation of the facts. So you have to appeal my decisions. And look, the
fact that you're not in a jail cell right now shows how impartial I am. That's not just courtroom banter. That's a deliberate rhetorical sledgehammer. The judge is drawing a boundary, pushing against his authority won't be tolerated, but he's also showcasing restraint. It's a sobering reminder of how much power a judge really holds in the room.
The fact that you're not in a jail cell right now shows how impartial I am.
When Officer Price literally pulled up to me my wedding days before any of this even happened and talked to us about the drunk and traveling, even told me I was well within my rights, gave me every clarification that I was well within my lawful rights. This was all a retaliatory thing from the beginning. And then even when the chief called me. He even called me trying to motor. I said, well, it's not motor. And then he goes towards the motor vehicle. And then he tries to get me to not pursue legal matters. And then he's mad at me. And then the day that I filed for my body cam, I'm getting removed from here on a Little League.
And stop. Hold on. I don't doubt that it is. But I think we got into this a little bit the first time you were here. And I told you, that's not proper for this venue. If you want to complain about the way the Huron Township Police Department handled this, you can file a civil lawsuit against them if you want to. But what's in front of me is one civil infraction and 2 misdemeanors. That's what's in front of me.
Oh, and every time I force it to make my case, the court just keeps setting all my stuff and not allowing me to do it.
Because I'm going to make decisions based on the facts. That jury hopefully is going to make decisions based on the facts that are presented.
How would there be facts in this court continues to not allow me to get my facts?
Because the facts you want to get into, what facts do you want to get into? The chief had some conversation with you?
It's not even just that. I mean, well, yeah, regardless, I have all of that to cover too. The fact that my offense, based off what I was doing, I didn't have to produce any of that. It just keeps all just thrown aside. Every single and just not even trying to acknowledge any of it.
So hold on. I don't understand. Hold on. You want to be able to testify to this jury?
No, it's not. I'm just finding. That's what I'm saying. It's the amount of traditional bias in this case.
I'm done hearing about bias. You need to appeal me. I don't feel I have bias.
Well, I don't feel that I don't have a fair trial here. But everything is going to take this line of file policy. Why I didn't?
And I've denied all these things. Well,
of course you can deny it again. Show them again. Then this.
Once again, Mr. Cruzel, just because I disagree with you doesn't mean I'm biased against you. Maybe I just think you're wrong. Is it possible we could have a difference of opinion?
Tina Green told me that she was just dying housing myself because the Secretary of State will make sure that this isn't a big deal. I'm showing.
I'm not going to.
It's so impartial.
I've never brought a Secretary of State, have I?
So in fact, this is where this all stems from. These are the things I've been trying to get noticed. This thing talked about.
What do you want getting noticed that we're not getting noticed? It is not collusion. What?
And
all
here
right.
We are. The judge is ready to bring in the jury, but Mr. Cruzel refuses to proceed, citing a rigged process. The clash is total. The legal system depends on a shared respect for rules and roles. Once that erodes, chaos takes over. This moment captures that breakdown in raw form.
All right, listen. What are you going to do today? Because I'm ready to bring the jury, and I've denied all. Stop! I've denied all your motions. I'm ready to set the trial. Are you not going to be here?
Again, Your Honor, hasn't established nothing is even fully here, right? And it's especially regarding the jurisdiction stuff.
Once again, we're at $300 now. We're going to 4. I'm going to ask you the question again. I'm ready to call the jury. Are you going to leave?
There's no way they're going to hear a trial here.
That didn't answer my question. I need to know how I'm going to proceed, because we can have the trial if you just sit there. I'll just tell the jury you've decided to represent yourself and you might not say anything today. So that's the way you want to go with the trial. Okay.
Everything is
Okay. Okay. No, let's on the record as you feel they should be.
I brought the sites that I left the sites at home and bring up the person's jurisdiction.
And hold on. Once again, I want to because he just walked in the room. Once again, I want to let you know there's a very competent, experienced legal attorney here, defense attorney here, that's more than willing to help you with this if you want his help.
Well, this organization was supposed to be.
And that ain't gonna happen.
Anybody showed you were supposed to release yourself. It's in the book.
I don't think I've shown bias. That's what we keep. Once again, you and I disagree. That's okay. That's America. You have to appeal me. You don't just keep to argue. You don't get to argue the same thing over and over and over until I agree with you. That's not going to happen. I know I am not biased towards you. I also know that your ideas of how the law applies in mine are vastly different. But because I'm in the black robe and I'm in charge of this trial today, my ruling stands until a circuit court judge or some higher court tells me I'm wrong. That's just the reality of it.
That's what I have to do. This court's not going to rule it the way it's supposed to. I'm not going to stand by your
Not by your definition, I'm not.
The Secretary of State, Attorney General, and you have never heard anything. I don't even know if you're lawfully allowed to concede it. You can say that again. It's been proven on the record.
No, it doesn't need to be proven on the record. Show me a statute or a court rule in Michigan that says I got to prove that. Statute, Michigan statute, or Michigan court rule that says I got to do that.
I have it in there. My father's in smoking.
So you're such a great legal scholar.
MCL 168.420 and MCL 168.467 mandates that the judge must file an oath with the state, and you provided 1X. That is what you have to ensure.
Okay, then I don't have it.
Let's pause and appreciate the absurdity here. We have a defendant citing obscure statutes, alleging foreign agent violations, and demanding the court prove its own authority, all while refusing to recognize its legitimacy. It's like two separate trials happening in parallel. But only one counts under the law.
I don't have it. You can file that motion to dismiss with the circuit court. But we're having a trial today.
We're going to have a Bob participating trial that's going to be impartial against them, right? It's going to be completed. There is no impartiality that is supposed to be here. There cannot be a fair trial for all of the amounts of evidence in there.
Okay. Anything else you want to put on the record before I call the jury in?
Yeah, lengthy statement I'll put on the record before we get.
How lengthy?
Minutes.
Go ahead. Just so you know, you're putting this on the record. You're putting this on the record. I'm not listening. Showcase the record.
Your Honor, Judge Oak, I respectfully assert that this court has failed to motions by files in the case. Yeah, well, then she can make Thank you. I respectfully assert that this court has failed to address the critical motions I filed in this case, including a motion to dismiss for lack of jurisdiction, a motion to recuse for bias, and a motion for relief from judgment. These motions have raised significant concerns about the court's jurisdiction, judicial bias, and violations of due process under both the Michigan Constitution and the U.S. Constitution, particularly the 5th and 14th Amendments. I have also submitted affidavits and motions, including an affidavit of truth and an affidavit of rebuttal regarding the traffic stop by Officer Merrill, which is connected to this case on August 21st, 2023. Citation number 24HR-101-430, which is court also ignored. These documents directly challenge the jurisdiction of the state in this court, and failure to address them constitute a violation of due process rights. Additionally, I have filed an affidavit of consent, a motion for judicial notice, a motion for clarification of accuses, and none of which have been acknowledged by the court. In Marbury v. Madison 5 U.S. 137, the U.S. Supreme Court clearly established that any law repugnant to the Constitution is void. I believe the acts were lack thereof of the fourth violent of fundamental constitutional principles. In Murdoch versus Pennsylvania, 319 U.S. 105, the court reaffirmed that no state may impose fees or penalties for exercising a constitutional right. And Thompson v. Smith, 155, reinforced that the fundamental right to travel freely without undue interference. Additionally, Title V U.S.C. 556D, 557, and
Title V U.S.C. Separation of Powers, Secretaries of State. This VO is packed with constitutional grenades. But here's the thing, citing federal statutes won't override a traffic citation unless properly applied. Mr. Kruzzel's effort is dramatic, passionate, and legally shaky. This is where courtroom drama meets legal reality.
557 and 706 require that any judicial or administrative proceeding be fair, free from bias, and based on factual evidence. I have serious concerns that this court has disregarded this evidence. I have serious concerns this court has disregarded these principles, given its pattern of dismissing my motions and statements made by Your Honor, who has stated on record that we see things the same way, referring to the prosecutor, township, state, and this court. This admission clearly demonstrates judicial bias and lack of impartiality, which undermines the fairness of these proceedings. It is also significant that Judge Tina Green has admitted in court that the Secretary of State is influencing the rulings, stating that the court is required to enforce certain rulings because the Secretary of State makes them do so. This further demonstrates that this court is not acting as an impartial judicial body, but is enforcing motor vehicle codes, other rulings based on external directives rather than applying the law independently. The Secretary of State is an executive branch agency, and his influence over judicial proceedings is a violation of the separation of powers and the constitutional right to an independent, fair trial. Furthermore, there is clear evidence between sport, prosecutor, Huron Township, including the Huron Township Police Department. I have submitted body cam footage highlighting the violation of department policies by several officers, including Officer Miracle, Officer Sysai, Officer Smith, and Chief Everett Robbins. These violations occurred even after Sergeant Price confirmed that my activities were lawful, yet this court continues to overlook these crucial facts. Officer Merrick's traffic stops of both myself and my wife are connected to the ongoing retaliation against me and my family, which has compounded the bias and misconduct in this case. Additionally, I requested Your Honor's oath of office through an affidavit of fact. Registration statement, demand request pursuant to the Foreign Agent Registration Act 1938 and anti-bribery statement request, and I have received no response. This lack of response raises further questions about the legitimacy and legal standing of this court. Moreover, Judge Lisa Martin issued an unsigned default order without jurisdiction or court seal, and during court proceedings, she admitted she did not understand the suit jurisdiction. These actions reflect further incompetence and violations of due process. I must also address the township's deliberate attempt to mislabel my private automobile as an off-road vehicle under local ordinance to circumvent my constitutional right to travel. This mislabeling is an attempt to subject me to commercial regulations that do not apply to private, non-commercial travel. This ORV ordinance was never intended for law public roads. Under the Federal Trust Code, or United States 318 U.S. 363, when government entities operate in a commercial capacity, they lose sovereign immunity and are subject to the same legal standards as private corporations. The court's actions, including the misapplication of commercial motor vehicle codes, further demonstrate its commercial interest and misinterpretation of the law. The Supremacy Clause of the U.S. Constitution, Article 6, Paragraph 2, mandates that this court is bound by the Constitution.
There it is again, the Supremacy Clause. It's a powerful constitutional provision, but invoking it doesn't automatically win a case. You have to connect it to the matter at hand. This is a classic example of arguing theory over facts. That might win internet debates, but it rarely holds in court.
Constitution, which is the supreme law of the land. This court, however, continues to proceed without regard for constitutional protections, violating my rights at every stage of these proceedings. To continue under these circumstances would be a violation of my constitutional rights and the abuse of judicial power. I respectfully request the court issue rulings on the pending motions, including the jurisdictional challenge. They immediately dismiss this case by citing overwhelming evidence of judicial misconduct, bias, and due process violations. So these issues remain ignored. I will seek immediate appellate relief, hold all the parties accountable, including Your Honor, Judge Martin, Judge Tina Green, Prosecutor Caitlin Margaret Foley, Officer Miro, Officer Sysai, Officer Smith, Chief Everett Robbins, and the Huron Township Police Department. I further assert that if this court continues to proceed with the presumption that I am engaged in commerce, it must present evidence to substantiate its claim. Without such evidence, This court has no authority to enforce commercial motor vehicle codes or ORV ordinances upon me, and any further actions would be unconstitutional and unlawful.
All right, here to court this report back in session.
Bring the jurors in. Mr. Crucell, just so you understand the process, we're going to do voir dire. Did you have a chance to talk about the iPad?
No.
Hold on a minute, Joe.
Yeah, I told him I would go over it.
Okay. I understand that's your position, but I'm still going to explain things as they go. All right. I mean, I just want you to understand what's going on. So if you decide you want to jump in, you'll know where you're at. Understood? I'm not trying to talk you into participating. I'm just letting you know what's happening. I'm going to explain things as we go for you and them. You got that?
I suppose I don't understand why I need to sit here and use my time for an
Because if you leave, I'm going to ask you a bench warrant and you're still going to have to deal with this down the road. At least this way, listen. Here, one of two things can happen today if we have the trial. Either they find you not guilty and you're done. Then you can file all your grievances and stuff. Or they find you guilty and you're just filing one more appeal.
instead of wasting everyone's time.
You've already wasted their time because they're all here. They're all here.
Well, that's why I filed these things weeks ago. These things should have been addressed before this process even took place.
There's a scheduling issue that takes place too.
So I,
But hold on. Hold on. Don't interrupt. You didn't appeal the last round of decision. You didn't appeal the decision you didn't like from Judge Martin. You didn't appeal the decision you didn't like from Judge Green, and you didn't appeal the decision you didn't like from me last time you were here. So here's my problem. I'm not going to adjourn today because you say you're going to appeal, because if you don't, we've accomplished nothing and we're no further to resolving these files.
and they have to file a link with the appeals court. I've been in contact with the appeals court.
Okay. Hold on. Let me try to educate you. Okay. You contacting the appellate court, first of all, this should go to the circuit court. All right. You've gone. Okay. So I didn't choose for you to be here, but you're here. Okay. So we have to get through it. All right. So the way it works is you don't just talk to them about an appeal. You actually file and perfect an appeal, but you didn't perfect the appeal. So there is no appeal. You started the process, but there is no appeal. So, Mike,
we're touching on bail. The judge explains he could set bond at any amount he wants. This shows just how much discretion judges have and how serious contempt can get. It's not a threat. It's a reminder that this isn't a debate stage, it's a court of law.
We're going to go forward today. The only question is, are you going to be in the chair or not?
No, again, if you were prevent for I'll have to state bond one, correct?
Depending on what I set the bench warrant at. It can be whatever I want it to be. Once again, but see, you think that's bias, right? And that's me explaining to you the way the process works. I could set a $10,000 cash bail on this. And until a circuit court judge tells me that's got to be set aside, it's the bail. That's the bond I set if I set it. Because here's the thing. And I'm trying to, listen, dude, I'm trying to get you to see I've got a job to do. It's got nothing to do with you personally. All right, you keep bringing this,
Next step is a competency exam. That escalated quickly. When judges raise this, it's not just about legal arguments, it's about whether the defendant understands the proceedings at all. This is a critical turning point. The courtroom shifts from adversarial to almost clinical. The judge questions whether Crucell is fit to even stand trial.
I'm having so much trouble getting through to you. I'm thinking the next step is a competency exam.
So that fact that she told me that on the record in front of me, and in all the things that she's saying, the judge said, she never said that on the record. I have a record submitted.
Well, once again,
she wasn't doing this because the Secretary of State.
Then appeal Judge Green's decision. I've told you that at least 5 times today. If a district court judge makes a decision you don't like, you appeal it to the circuit court. You don't just keep arguing again. That doesn't get you any further along. So if you don't participate today, if you just sit there, that's fine. We'll have a trial. You can jump in if you want to. You don't have to. I mean, in any criminal trial, the defendant doesn't have to do anything. But at each step of the game, I'm going to let you know what your options are. So for example, when we do voir dire, I'm going to ask questions of the prospective jurors. She's going to ask questions of the prospective jurors. You can ask if you want to. You don't have to. All right. When it's time to pick the jury, she has a certain number of challenges she can use. So do you. You don't have to exercise those challenges, but that's the way we pick the jury. Do you understand that process?
Marcus is up and trying to get all this stuff established with the courtroom too. And I still have evidence that I'm trying to get from the township that they're using lead codes for that.
And now we hit discovery. Mr. Crucell claims withheld documents. But discovery rules are specific. Redactions for security, lien protections, and scope all matter. The judge listens carefully here. If Crucell can prove withheld exculpatory evidence, it could actually shift the case. But right now, it's just allegations.
Codes for that, of course, they did with the policy information that I gave and got them to give me the policy because they were trying to do things up.
Okay, stop right there. Hold on. Stop right there. Stop right there. That's something new evidence you're waiting for. What are you waiting for?
This is where I haven't got it to even get to.
No. Tell me what it is. What?
Evidence that I requested before is in the very beginning with my bottle camera.
No. But what is it? You're looking for some records, some ordinances? What?
Part of the traffic comments and things that were put in there. That
Hold on. In where?
in the comments.
You don't have police reports?
Well, I do, but I found out that they held certain documents that when I filed my FOIA, they didn't give to me. And then upon doing more filing for more stuff, I uncovered that they withheld certain documents. They were getting the whole thing.
Hold on. Let me hear what you just say. Just hold on. Go ahead. Do you have any idea what he's talking about?
He's bringing things from the sound notes and
You mean like the officer's personal notes? Had notes.
and for example, buying a camera where they're sitting in your patrol car and the computer's on. Those are all lien material that can't be discoverable. It can't be shared with people outside those that are have the security clearance to observe or handle lien material. So that's what he's referring to.
Okay.
That's not what I'm referring to. The notes on the computers and stuff, that's not what there's even stuff that was in the body cam that when they were talking with the chief that they purposely redacted out of the conversation to the notes that that are completely all redacted. It's nothing to do with computers. It has nothing to do with personal information and names or addresses. There were things that were stated in conversations that were taking place in these notes.
Let me stop you. During the traffic stop?
I don't know that they withheld this when they should have given to me in the very beginning with my FOIA for everything else involved in my traffic stop. They didn't.
Okay, hold on. I'm trying to clarify. Are you talking about like, how do I want to say this? Personal comments between two or more individuals?
No, it's not horses boundness. It's stuff that's logged through the traffic stop. Like,
No, stop. But I got to understand what you mean. Logged through the traffic stop. You mean it showed up on camera and then they edited the camera?
yeah.
Or edited the recording?
That's what. Yeah, there was no clear reasons why. Every time I try to get reasons to why they didn't run this connection because they're supposed to label why it is. I haven't got anything. And then it's in the comments sections of like what was going on.
Hold on. Comments on the incident report?
It's not the incident report. It was through the while the traffic stop was taking place, stuff that's being entered through like I can't remember exactly what the paperwork is I am. Like I said, I'm in the process of getting it all. I'm appealing to the supervisor and that and he vaguely just cited statutes and codes, but he was supposed to tell me how and why I didn't even see the applies to the lead sections, which are failing to do because
all right, so hold on. So what I'm hearing, I want you to confirm whether or not I'm hearing it correctly. I think what you just said was those comments section things that you want, they're telling you that's all lien stuff and it's protected.
yeah, I have other
Hold on. Is that a yes? That's what they're telling you?
essentially.
Okay.
So, and part of the site of the whole thing they forgot from that. They didn't do it in any of the other ones. Only
Hold on. Other one what?
all of the because they're in several books. Several times the cops came out of their house. I think we were told, well, this has been going on for all of years. Probably by incident.
Okay.
So I filed every cop that had been there, all the reports, anything to do with anything that I could get that was access to me. And then that's how I found out that these other reports weren't released to me. And then in my life charts, they did the same thing. Everything to do with that entire traffic stop is all completely redacted. But yeah, any of the other stuff, it's all open.
Redacted from,
The whole page is black.
hold on, redacted from the incident report?
Yeah, from the incident.
The paper report that you received?
Yeah.
Okay.
And there was no justification involved for why any of these things are redacted. I keep trying to, and then how they did this policy. I tried to get the policy 3-7 times to the department, and then they cite these lien codes for names and addresses and stuff, which I understand there's certain stuff.
What policy?
The policy conduct, officer conduct, and how the officer is supposed to operate and stuff, right? So they denied several times, stating lien codes are trying to use all these connections now. So I appealed it to the township supervisor, and he released all of my information, and it showed that the policy showed that these officers violated the policy.
These officers violated policy. Powerful accusation. If true, this could open the door to civil claims. But again, the judge is keeping this focused on the citations. Remember, misconduct and bias may be relevant in another courtroom, not necessarily this one. The judge's job is to protect the jury from irrelevance and confusion.
Okay, hold on. Stop. So he released everything, but not everything you want?
Well, then once I realized they were doing this, I went back to even more. That's how I found out there was more stuff that was under released to me.
Okay.
And then doing the same process using these lien codes to not let me see what was put in this hearing. And that's why it's all the record titans. I've been trying and fighting all this full time trying to get this stuff together. And I'm getting every which way. I'm being screwed.
He's raising issues that concern me. Because now we're talking about discovery requests that are being partially fulfilled.
As you can see, as it is with this stop, he does have the incident report. He does have body on camera for 4 officers, in car, dash cam, what have you. He also personally took video. I have it. There was no mutual discovery. He elected to use the FOIA route to take all this information. What he's referring to again is the CAD information where there is the material. None of that affects what the substance of the incident report or the body worn camera or anything of that effect. He's also talking about incidents that I think they were probably about the township attorney is dealing with it as opposed to the township prosecutor. There's probably about 20 different contacts that he has sought FOIAs through. So it's not just this incident. And what I suspect he's talking about where police came to his house or like a traffic stop or speeding ticket, there are no incident reports. Those are CAD. So that's probably why those are blacked out as opposed to this incident where a misdemeanor was attached and an incident report had to be done.
The prosecutor confirms Crucell used FOIA instead of standard discovery. That's a critical distinction. FOIA is public record access, but criminal defense discovery involves a whole other process. This shows the limitations of going pro se. Navigating procedure without a lawyer can severely weaken your position.
Okay. Anything else as far as information you requested that you don't have that you think you need?
I mean, that's the base of it. I'm still actually, now that I've been having to really dig into stuff, I'm uncovering more. Now that I've been through the body cams, I have to file more to get more stuff unredacted because there is clear points in these conversations that will purposely redacted. They have nothing to do with any information that they keep claiming. Same thing with these cat she's referring to. That's not what I'm trying to get hold of them. And I understand that there are things that they can redact through the lien code. But these entire things that are, there's no way the entire pages and these comments and everything are all lien information. I know that I've been told.
How do you know?
I've been told for Sergeant Price things that are said in these personally about me and stuff like that are being redacted because it can be used showing the bias and the retaliation against them. And I know for a fact what was said in these things. That's why I know that being redacted is more than much to say.
Okay. But Mr. Crucell, with all due respect, that all sounds like a civil lawsuit against the township.
Well, yeah, this is my argument. I'm trying to bring it to this court, but everything's just being getting.
Because I'm not going to get into all that with a jury.
but that it goes directly to this, is what I'm saying. And that's why I've been trying to get all of this stuff answered before we even come to this point.
I'm not going to let you get into all that with the jury. It's going to be confusing. We're going to go down rabbit holes.
That's why what's because I need to go present my case to fair.
This case goes back to February. The last we set this trial 2 months ago.
You're right, but
2 months and 2 weeks.
I'm trying to get the jurisdiction established. I'm trying to get the judicial bias stuff taken care of. All of these things that have not that they just keep. It is what it is. Being swept under the rug. When
Okay, hold on. Once again, I have to take offense to that. I'm not sweeping your judicial bias argument under the rug. I'm denying it.
Without it, I give you.
The judge finally lays it bare. He doesn't need to hear all of Kruzzel's bias evidence to know he, personally, isn't biased. This VO is more than legalese, it's existential. The court must act on law, not feelings. If a judge knows they're acting within the rules, the burden of proof falls entirely on the accuser.
Okay? No, seriously. See, it doesn't matter what you have to say. If I'm determining bias, I know what my heart is. Now, you appeal that decision, or you grieve me to the Judicial Grievance Commission, right? They can look at all your facts and say, well, Oakley, clear bias. But I don't have to hear all your arguments and see all your evidence to know I'm not biased.
That's fine. And I guess that's something that I have already started to do a process. I will be going down it. The more I do it,
okay.
So again,
sir, it's 9:02. The jury's been here since, I'm assuming, shortly after 8. Some of them were showing up.
Yeah, like I said, I cannot participate in something that I know is stacked against 100%.
Well, once again, you think it's stacked against you just because you don't agree with the way things are going. Okay.
Show that these things have to be established. There has to be a
Then
you see bias like that. See, I mean,
okay, stop. We're just hashing the same arguments again. If you're right, then you've got an automatic appeal if they convict you today.
And the courtroom fatigue is real. Bring the jury in. I'm tired of talking. This VO is the human side of the judiciary. After hours of circular arguments and rejected motions, the judge is done engaging. It's time to move the case forward, one way or another.
If you're right, and this whole thing has been nothing but a sham.
it has to be. And it's all this turned into.
Okay, bring the jury in. I'm tired of talking. Motion who? Oh, I forgot you filed a motion. Give me just a moment. Yeah. Did you see that? Hold on. Did you get her motion?
I never seen that.
Yeah, no. Just, you got a copy. You can just at least show him so he can see if he's seen it before.
When did you send this to me?
Last Tuesday, along with our consultants.
I have never seen this.
Take a minute to look at it.
Let's bring up for the record.
Hold on. Hold on. Have you had a chance to look at what you just handed me? Okay. All right. So are you ready to argue that motion?
Well, no, I haven't no time to prepare for anything. I've never seen that before. And
Okay.
it's just trying to keep me from being able to bring up all my valid arguments that are all applied to this.
Once again, valid as you determine them,
These are facts to the case.
as you say.
And that's they're the same with the things they're trying to say, right? They have no evidence. Where's the evidence, right?
Right. But I haven't ruled that anything she's trying to put in front of the jury is invalid.
So my defense to my
Well, here, let's do it one at a time. She wants to stop you from saying anything about due process violations. Did you plan on telling the jury that your due process rights have been violated?
all part of this case.
Okay.
Same thing with all the traffic stop all the way till now.
Specifically, what were you going to tell them about your due process violations?
Well, I don't have my defense completely in front of me because I'm trying to get all the other matters. I'm not ready for that. So I've never even seen it, so I can't even build up a defense to that.
How was that provided to Mr. Trussell last week? Okay.
I received his motion, or his 109 motions on Thursday, so it didn't give me much time to respond. I did send it in the mail. I dropped it off at the post office this morning. And I didn't receive his most recent motion.
That was filed Friday. Right.
I sent a letter certifying mail, so I know what you're saying. I mean, we've never got first last name. Never.
All right. So here's what we're going to do. If you decide to participate and present any evidence to the jury today, then if any of these A through E's come up, we'll deal with those as a point on a point by point basis. Understood?
Yeah.
I'm not, sir, I'm telling you, you don't have to. She wants me to give you a blanket instruction right now that you can't talk about any of these things that are listed in this motion. I'm not going to do that. If you choose to present anything to the jury and one of these topics come up,
the prosecutor moves to limit testimony on constitutional violations. The judge doesn't preemptively block it. Instead, he handles it case by case. This is fair judicial practice. It prevents stifling a defense while preserving courtroom order. For a contentious trial, that's a razor-thin balance.
these topics come up, she's going to stop me probably with an objection, say, Judge, could we talk about that? And then we'll talk about that. Item by item. Understood? All right. Anything else before we bring the jury in? You said you wanted to say something before the jury came in. I thought you said.
Another point to this, I filed for records of Weston's court, trying to get all my court hearings and everything in orders. There's still one from the very first one from Judge Martin that is crucial to this case. They still have issues.
How could it be crucial to the case today?
These proceedings involved. I need to.
We should probably have Caitlin.
Yeah, and she's gonna move.
All right, back on the record with the People versus Crucell. All right, Mr. Crucell, I just want to put on the record the conversation that we had.
We get a rare behind-the-scenes look here. The judge candidly explains the role of public defenders and how Mr. Bowage doesn't work for the court. Transparency like this is crucial. It's also smart PR, showing that the system isn't conspiring against the defendant, even if it feels that way.
We had out in the hallway with Mr. Bowage present. Outside of your hearing, by the way. That's for that. But I filled you in. So you've agreed you're going to pay your $300 contempt charge. I put that in air quotes. I'm going to apply that towards the cost to pay this jury panel for being here today. Agreed? In exchange, we're going to pick a date, hopefully in the next 2 minutes. We're going to pick a date, put this back on our calendar down the road to give you plenty of chance to perfect your appeals, whatever you want to appeal. Agreed? Okay. All right. You can sit down. Okay. Now, but I have to say some other things. All right. Before I took the bench, I did a lot of court appointed work. All right. So I know that a lot of times when a defense attorney is talking to their client, they've got to get over a mental hurdle because a lot of people in a situation where the court's provided the attorney, they think the attorney's not working for them. The attorney's working for the court. So I want to make sure you understand how this works. Mr. Bowditch, although we've worked together for years, he doesn't work for me. Really, he doesn't even work at my pleasure. I suppose if all three judges in this court told the Michigan Indigent Defense Council Regional that he works for that we just don't want this guy in our courtroom anymore because he's just incompetent or whatever, they'd probably put him somewhere else. But other than something drastic like that, he's not here because I'm paying him and I've requested him. You understand that? Okay. His job, his client is MIDC. And I say his client because they pay him, but he's paid to represent folks in district court that don't have their own attorney. I just want to make sure you understand when he's giving you advice, he's not telling you what he thinks is best for me. He's telling you what he thinks is best for you. Okay. Now, the other thing, I'm assuming he brought my offer out to you. Listen, if you want to get into all those arguments that you've referenced today and the last time you were here, I'll give you that. I mean, I'll look at all the stuff you've got on the traveling argument, everything else, because what I told you earlier is I've got an open mind. Okay. I don't think in my heart of hearts, you can convince me that your argument on traveling is a valid one, but I'll listen to everything you've got to tell me on that and every other issue.
Here comes the judge's offer, a bench trial. This is significant. The judge is open to hearing everything Mr. Crucell wants to say, just not in front of a jury. That's a huge strategic fork in the road. A bench trial allows complex arguments, but removes the emotional appeal of a jury. Would you take the offer?
In every other issue. I mean, I'll give you an entire day set aside for a trial to do all that, but not with a jury. All right. So I want you to know that's an option. I'd like, and if you need to have some conversation with your family or Mr. Bowditch, I'd like a decision on that today, because when you walk out of here, I'd like to have a date on the calendar for either a bench trial or a jury trial. Okay. And I hope, based on my earlier conversations, you understand why I can be much more free and easy about what I let in when it's just me making the decisions than it is with a bunch of jurors. All right. Bowditch, go ahead.
Could we actually adjourn this? Now, Mr. Purcell and I have had a conversation. I think we can streamline this case quite a bit. Could we set another motion date? It's nothing that's been covered. We covered new ground.
Okay.
It should be a simple motion with his understanding. It's yes or no. And then if we need to proceed to a bench trial, we would.
How far down the road?
Well, it depends on how long his discovery is going to take. If there's anything even possible to be retrieved, but I still so.
Probably a month is too tight.
Well, I know that's in the process. I've already appealed to the conference. Now I'm in the process.
Okay. Hold on. I think so. October 21 is too tight, I think. October 21, I think, is too tight. Time frame wise, you want to go into the next month?
We can, Your Honor. It's up to the courts.
I have no idea how that process is going to work, so I don't know.
Yeah, I mean, I'm more time.
With what the court's done today and asking more favors.
No, you're not asking a favor. We're just scheduling a date.
Do you do
What is it?
that's a Monday before Tuesday?
Yeah, that was
We'll
it.
open that day.
That'll be so.
If Caitlin is.
Do you have an opening on Monday the 25th? You're not scheduled.
Of November.
Just for a motion. This is just a motion hearing. We're not going to take testimony. Okay.
As long as you're not, no,
Don't-
you don't have them that month, let's say.
So that'll work?
Scheduling is tactical. The court agrees to a new motion hearing, pushing the trial down the road. This is a win for Mr. Crucell, giving him time to organize his appeals and build a better defense. For now, the storm has passed, but the battle is far from over.
What's the date?
9 a.m., the 25th of November. It's the Monday before Thanksgiving. Nobody's got travel plans?
Motion date.
Okay. So I think what I'm hearing is you think that will either be dispositive or we'll set a trial date that day.
Yes, Your Honor. Or we'll resolve
Okay. All right.
it.
Okay. I didn't ask. Can you pay the $300 today? Okay. And I implore you, keep talking to him. Keep talking to him. All right. Anything else? All right. We're adjourned. Yeah, go ahead.
Officers are here and you're ready to testify.
Understood. And you can give them my apologies. Put it all on me. So your civil infractions, we're just kicking those down the road. Understood? Okay. Or I keep saying infractions. It's two
misdemeanors, one civil infraction. That's the core of this whole spectacle. For all the shouting and motions, the case centers around relatively minor charges. But what we've witnessed is the system clashing with ideology, personality, and emotion. And that's what made this hearing unforgettable.
infractions. It's two misdemeanors, one civil infraction. All right. Okay, so everything's adjourned. I'll make a note in the file so the cashier knows what to do with your $300.
Mr. Bowditch, as your,
Not officially, I don't think.
let me just give you notice.
Did we set that at 8:30 or 9?
You said no.
9? We set it at 9, but if he's always here early, she'll probably be here early, so get here early, we might get it done with.
And that brings us to the end of this explosive hearing. Mr. Crucell may have bought himself more time, but the legal storm is far from over. From fiery due process arguments to an avalanche of denied motions, this courtroom drama had it all. we saw the raw tension between authority and autonomy, legal procedure and personal conviction. One thing is clear, representing yourself in court is a high-wire act with no net. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. Until next time, stay sharp, stay curious, and stay informed.